then you are taking away the right to acquire removable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e). You virtually took away the fundamental rights.
They got their fundamental right, 35A goes. They got their fundamental right, 35C goes. And I will come to, my lord, several other, my lord, provisions which were working against the interest of the people, but they were convinced. Now they have realized what they have lost. Yes.
I was just looking at the 1954 order, CO 48.
Yes.
That applied the entirety of Part 3.
Yes.
And then made certain modifications. Yes. Therefore, Article 16 applied, Article 19 applied. But now see what happens. If you look at the CO, it applies Part 3. That is Volume 3. You get it at Volume 3, page
14 months.
Page 14.
Yes.
Volume 3, page 14. But you bring in Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of immovable property, 3, settlement in the state, leave aside scholarships. So though Part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19,
14.
And 16(1), then you are taking away the right to acquire removable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e).
Right.
So though the Constitution expressly made the provisions of Article 19 applicable, which would include these 3 rights, and Article 16, by enacting 35A, you virtually took away the fundamental rights.
Employment is also right to life.
But there's a direct right under 16(1).
Yes. No, employment is a separate right and would fall within separate category of right to life.
No, that itself was not taken away. What was taken away was employment under the state government. Because what 35A did was, it says conferring on such permanent residents any special rights and privileges or imposing upon any other persons, any restrictions. So it does both things. You can give special rights to residents and you can take away that right insofar as non-residents are concerned. Employment under the state government. Employment under the state government is expressly covered by Article 16(1), because 16(1) says there shall be equality of opportunity for all citizens in matters relating to employment under the state. That includes the union as well as the states. So while on the one hand, Article 16(1) was preserved, 35A directly took away that fundamental right and granted immunity to any challenge on the ground that it would deprive you of a fundamental right which is protected by 16. Likewise, 19. 19 recognizes the right to reside, settle in any part of the country.
Right to acquire property.
And then, property then was 19.
Now it is 300.
So all 3 fundamental rights were essentially taken away by 35A, which was brought in by CO 48.
It continued till 2019.
Power of judicial review was taken away.
Judicial review was taken. So it is beyond 9th schedule. Almost put at par, beyond 9th schedule also. And this continued till 2019, till the impugned resolution, impugned CO was passed. Therefore, my lord, I am respectfully urging that please look at the matter from the point of view of people of Jammu and Kashmir. Something which is impugned before your lordships is a constitutional exercise of power which confers fundamental rights, which applies the entire constitution, which brings the Jammu and Kashmir people at par with their rest of brothers and sisters, and Lord applies all laws which are welfare legislations, and I have the list which was not applicable to the state of Jammu and Kashmir. And the very unfortunate part is, and this is really, my lord, a troubling part, that till now the people were convinced by those, my lord, who were supposed to guide them, that this is not a hindrance in your progress. This is your privilege. You fight. Nobody can take away 370 from you. That is the most unfortunate part. And your lordships have, my lord, at least two major political, I'm not being political, major political parties before your lordships defending 370, including 35A. When your lordships ask, what did you lose out of it? There is no list. This is what the people rightly lost. They got their fundamental right, 35A goes. They got their fundamental right, 35C goes. And I will come to, my lord, several other, my lord, provisions which were working against the interest of the people, but they were convinced. Now they have realized what they have lost. Because now, because of 35A not being there, investments are coming. Now, because of, my lord, the law, I'll show, my lord, from the Reorganization Act, because of the policing being now with the center, my lord, tourism has started. Jammu and Kashmir traditionally didn't have much of big industries. They were cottage industries, small industries, etc. Main, Lord, the source of income was tourism. Now tourism has started. By now, Lord, 16 lakhs tourists have come. New hotels are coming up, which gives employment generations for the two large number of people, right from Tangawala to Lord, officials. I'll come to that. So,
in a manner of speaking, 35A is not a modification of Article 35. It is a creation of a new article in the Constitution. That's where I'll make this assertion.
The scope,
It's not a modification at all.
the scope of expression, exceptions and modifications
That's right.
will also
So virtually you created a new article in the
a
Constitution.
new provision.
That's right. It's not a modification.
it's not a modification. Therefore, I respectfully urge 35A is creating a new provision in Constitution of India only to be applied to Jammu and Kashmir. Now, my lord, if a lady marries outside Jammu and Kashmir, she loses permanent residency. There are several such things, my lord. People coming from West Pakistan who were, my lord, settled down from decades were not.
The first part was struck down by a 3 judges bench of the J&K High Court.
By the High Court, my lord. I'm sorry, I was not aware of
In
it.
terms of view, 3 judges bench.
I'm told that children will not get. So whatever, my lord. That's now.
How do say children will not get it? It was a nebulous situation which will get.
Sheila Sani is
That's
there.
all.
Now, my lord, kindly come to page 57. And my lord, the argument was that why did you not consult ABCD? My lord, out of ABCD, ABC is proclaiming that 370 is our right. Official, that's the official stand. So leave it at that. Please come to page 57. Now, my lord, use of mechanism under Article 367 for the interpretation of Article 370 for the first time. But any provision of the Constitution can be amended by executive action or constituent action, my lord. No, without bringing the parliament. Therefore, my lord, 367 is a legitimate use so long as
Into the constitution as applicable to the state of Jammu and Kashmir
only.
by CA 48 of 1954.
Correct. So constitution was amended, which was 30, that was 370. You can amend the constitution or you can apply existing provisions.
Under 370, a CO was issued, and which brought in a sense, 35.
Correct. Now, my lord, page 57. But as I pointed out, whenever the situation required it, 370 remained floating. Whenever some changes were required, depending upon the circumstances, they were made through the mechanism of 367. 367 is an interpretation clause. So the interpretation was made. Now, please come to page 57.
Yes.
Sub-article 4 was added in Article 367 as applicable to Jammu and Kashmir. This sub-article 4 is not applicable elsewhere. It's only for Jammu and Kashmir. For the purpose of this constitution as it applies in relation to the state of Jammu and Kashmir, references to this constitution or to the provisions thereof shall be construed as references to the constitution or provisions thereof as applied in relation to the said state. Then references to the government of the state shall be construed as including references to the Sadri Riyasat acting on the advice of his council of ministers, because by that time Sadri Riyasat had come. References to a high court shall include references to the high court of Jammu and Kashmir. D. Please note this, my lord. References to the legislature or the legislative assembly of the said state shall be construed as including references to the constituent assembly. They were used interchangeably.
There's no function.
That time there was no legislative assembly.
At that time, there was no legislative.
No, it was, my lord, to be made immediately. Therefore, my lord, in advance, my lord, they must have made a provision. There was none, my lord. This is 54, so there was none. Because the constitution was framed in 57.
So in terms of giving representation to the state in other forms, it would require Constituent Assembly to be interchangeably used so that till the Constituent Assembly finalize something, it would not.
No, my lord, another purpose is that till the legislative assembly comes, somebody will have to make laws other than constitution. They were made. The Constituent Assembly after this functioned as a legislature of Jammu and Kashmir also. And they made other laws also. I have given the list.
It was primarily to ensure enforcement of 370 articles or clause 1, which power was vested with the legislative assembly. So they vested it with the constituent assembly.
Constituent Assembly, so that laws can be made by the Constituent Assembly. Otherwise, my lord, Constituent Assembly is not a law-making body in that sense. Of course, my submission is that Constitution of Jammu and Kashmir is at par with the legislation only. It's not, my lord, a kind of a constitution as we understand, my lord, as a document of governance.